Welcome back to Business Agenda. Well, the Fair Work Commission recently upheld BHP's decision to dismiss an employee who refused to comply with the company's clean-shaven policy. The case raises some interesting questions just on how far employers can insist that employees dress and appear in a particular way. Well, here to tell us more, our workplace law commentator Joydeep Hor from People and Culture Strategies joins us now. Joydeep, great to have your company on the show this afternoon. Just give us some context. What exactly happened here?
So in this particular case, and good afternoon Ingrid, BHP had introduced a policy requiring employees to be clean-shaven. Now this wasn't something they introduced just because they thought it would be a good look. They considered that that was a necessary policy to introduce and enforce for safety reasons, and the specific safety issue was that they needed employees, some 900 of them, to be clean-shaven in order to wear some personal protective equipment that would be covering the face, a helmet of sorts that would still allow them obviously to breathe, so it had inbuilt respirators and whatever else. This case involved one of the 900 employees refusing to comply with that direction, claiming that he would be willing to fund at his own expense a separate, more advanced respirator, and on that basis he should be allowed to keep his goatee and moustache. So he was dismissed by BHP for not complying with the policy. He brought an unfair dismissal claim, saying that the policy had not been the subject of proper consultation with workforce, said that it was unreasonable, said that he'd offered a solution that would have dealt with the safety issues, ultimately lost his case in the eyes of the Fair Work Commission.
Is it because it was a safety issue more than how he looked that's why it was upheld by the Fair Work Commission?
I think it's a really good point. I think that the Fair Work Commission is always going to look at why the employer is imposing a particular policy or requirement, where there's a safety issue involved, and so long as it's a genuine safety issue as opposed to a very perhaps conservative view about what's a safety issue, which employers are often guilty of adopting in terms of their approach, it's always going to find more favour with the Fair Work Commission. Having said that, Ingrid, what's important to understand is that there have been some cases where employers have been able to justify employees complying with these kinds of policies because of the brand and the look that the employer wants to have. A very well-known case where an employee working for Star City Casino was effectively required to remove a tongue piercing because of the look that the employer in that particular case wanted employees to have.
Right, particularly if they're the face or the brand of the company. But in terms of employees suing for discrimination and getting through with it, what sort of instances allow for that?
Well, if the particular item of clothing or jewellery is somehow necessitated by a particular religious belief or a particular racial or national origin, preference or requirement, that's always going to be something that employers need to be a lot more careful about, because that's treading into pretty dangerous potential discrimination territory. So the employer is going to have a much harder a task ahead of it in terms of justifying that even safety requirements in those circumstances should trump the important matters of religious pursuit and preference.
So any advice for organisations that are sort of faced with this?
Well, I think that employers need to be very clear about what are the essential requirements that they have within their organisation, as opposed to what might be desirable. And you see this over the years in a number of different contexts. All employers, all managers are going to have preferences, but when it comes to these matters being tested legally, the rubber will hit the road when the employer is tested on the question of whether something was essential. Even in this particular case, BHP were able to prove that notwithstanding the employee had offered to fund an alternative, that would impose considerable additional obligations and problematic obligations on BHP, because they would have to do additional testing, etc., from a compliance point of view. So employers need to be very clear on it. Communication is always the key. Talking to your workforce about what's needed, why it's needed, is always going to put you in good stead.
All right, Joydeep, thanks so much for those insights.
Pleasure, Ingrid.